It's great to welcome you all back. Welcome to the second of our Lunch and Learn workshops for the financial year. And probably following the success of our first workshop, it's great to be back and to continue to share some key other items. I know, we've been doing our Empire Masterclass shows. Well, I've got another Women in Accounting show on personal branding coming up as well, which all of you will get an invite to. But this is just a little bit different. So if you're joining us for the first time, my name is Paul Jantz, and we are here thanks to Professional Partners Education, the division that I run, and our friends at Chadwick. And again, the idea of this is not to provide you with, and the feedback has been not tax driven as much, because I think a lot of you do get a lot of different tax information and you attend all the different training that you need to do. So we're here to provide you with something a little bit different. And today's topic we're going to talk about is to Phoenix or not to Phoenix, which is always interesting. You would have all been invited here as friends of Professional Partners Education, or what we call PPE, and Chadwick, as you probably attended one of our lunches more recently in Melbourne, Sydney, Brisbane. We're continuing to do them. We've got one coming up in Melbourne. Danielle might actually say something soon if she's on the chat bar, but we've got one coming up in Melbourne soon. We've got coming up in Sydney soon. I'm all over the place. I've got no idea what's going on. But yeah, look, obviously you're here because you come to one of our lunches, you've attended one of our sessions, we've taken some great feedback from you, and it's more in this insolvency space that we want to continually provide you with some content and anything that can obviously help you towards CPD as well. So certainly sit back and enjoy the next 40 to 45 minutes. Let me introduce you to today's guest. It's probably one of our most experienced partners at Chadwick. So welcome, Richard Croaker. How are you?
Really well, Paul. Thanks for the opportunity to come and talk here.
Yeah, always good fun.
Yeah, it was nice to go over some notes earlier on this actual topic. And as I was saying to you a minute ago, that it's an emerging area that's become more important, particularly since about 2020, where we've started to get some more information about it. But it was good to go over those notes. Looking forward to sharing some information. Yeah. Brilliant.
To all of you guys online, you've got the chat bar, you've got the Q&A bar, which I'll moderate as well. But what I thought I might do is just kick off, because there was a number of firms that also didn't have access to our first workshop. So if you've come on, what I thought might do is just kick off with some key messages from last month's workshop that we did. So these are going to come to you on the first Tuesday of every month. Again, hopefully some stuff that we can bring to you that's quite fresh and new as well, things that hopefully you don't know about. So mate, we spoke about payment arrangements, payment arrangement defaults, director penalty notices, early signs of a business in distress, ATO collection policies, because we were lucky enough to have Kathleen Boris on here last month to share some things from a recent insolvency conference. And then you spoke about 3 ways to restructure a business as well, Rich. Anything you'd like to give us a quick little wrap up about? Is there anything that I've missed that you might want to just go over quickly?
Look, you'd certainly touched on the agenda for that particular meeting, and I managed to give Kathleen a call and just recap on what we'd spoken about, because she covered quite a lot of ground in that particular webinar. But I think the take homes for accountants in practice at the moment are that the tax office will certainly consider new payment arrangements even when there's been payment defaults. We're seeing evidence that will spin out to up to 3 years for repayment. There is argument that the tax office will go out to 5 years, but there's got to be pretty well extenuating circumstances to be able to make that work. And I think that's part of the ATO's mantra, that we're not trying to create problems here, we're trying to solve them. So I think that's worth noting, that if you've got clients who've got payment agreements and they've defaulted on those payment agreements, don't be scared to go back to the tax office and see what else you can negotiate. The other thing that Kathleen mentioned was the director penalty notices, and as she said in that webinar, that some time ago the ATO had issued some 50,000 letters to directors asking them to engage in relation to outstanding payment outstanding taxes and payment arrangements, and they found that there was only about a 25% take up on the people who were prepared to engage. And what we're now seeing, and I suspect accountants generally are starting to see that payment arrangement, director penalty notices are starting to be seen in the wild. That they are turning up at directors' doorsteps and at the registered offices. They originally started to the tune of about 50 a day, but I think they're running about 100 to 150 a day now. And our view is that's going to ramp up even more. So I think that was another take home from that. And then
Can I interrupt one, because there was a really important one to everybody that's listening as well. You mentioned it just before in terms of registered officers, and there's also the timeline. So one of the critical factors that went back and forth with a number of firms was making sure, one, the registered office is up to date.
Yeah.
And number two, it's the date that the letter was sent. So with all of us maybe still, well, I know I am working from home and you are, that's an important point, because if that director doesn't receive that notice and you're past the due date, there's problems.
Yeah, look, in actual fact, a director penalty notice will ordinarily be delivered to the home address of the director, right? But I have seen cases where the director penalty notice has also been sent to the registered office for one reason or another. But I think the thing to be aware of there is that it's not only that information at ASIC is not only important for the directors in relation to the potential for director penalty notices or anything that relates to them as a director personally, but it's also in relation to the commencement of winding up proceedings. And I had a look through the list of participants here, and I noticed that one of the guys that I do a fair bit of work with, Levi Smoohar, is actually in here. He's a lawyer in Brisbane. And Levi has talked to me on a number of occasions about how the winding up process works. And you start with a statutory demand, and it's going to end up at the registered office. You get the winding up application, it's going to end up at the registered office. And I hear it so many times when I'm talking to directors. They say, "Oh well, I never received the winding up application, or I never received the statutory demand." And I'm sure that there are cases where people like Levi have successfully defended that sort of stuff, but in general, that's a pretty hard case to run. I think it gets back to the point: just make sure that your information is up to date. So moving on there, I don't really leave. Kathleen was also speaking about the early warning signs of business distress, and look, there's been enough talk about that over many years, going back to ASIC versus Plymouth many years ago, the indicators of insolvency produced by the judge at that particular case. And then we moved on, and I had a chat about the three types of restructuring that I work with, which are an asset-based restructure, an equity-based restructure, and a debt-based restructure. And in relation to the debt-based restructure, I'm particularly referring to a creditor's voluntary liquidation. Potentially a creditor's voluntary liquidation, but it could also be an equity contribution from the owners of the business or new partners in the business to re-establish equity levels. And then in relation to a debt restructure, well, that's of course typically voluntary administration, but it can be an informal agreement. We spoke about that sort of stuff as well. But I think the interesting part out of that is that what we're talking about today in relation to the Phoenix rules, that this is really a progression of what we spoke about the other day in terms of that form of restructure. And we'll talk about that as we go forward from here.
Yeah, good. So let's get into that, because it's great to always do a quick little recap for those that might not have been on that first session. So to Phoenix or to not Phoenix, and this came out of a report. I know it was released by Hall Chadwick as well. It came out of a report commissioned by the Fair Work Ombudsman in June 2012, I think, entitled "Phoenix Activity Seizing the Problem and Matching Solutions." Mate, tell us a little bit about that.
Look, over the years, there's been all sorts of inquiries and stuff relating to Phoenixing. And I remember back in the early 00s, Nick Sherry, who was the head of the Senate Select Committee, worked on this back in, I think it was about 2004 or something like that. And he referred to the transfer of business from one entity to another which is basically what phoenixing is, the transfer of one entity to another where the parties are related, and in his words, is a legitimate use of corporate form. And I think that we get confused with the term phoenixing versus illegal phoenixing. And I mean, in the context that we're working in here, phoenixing is an illegal type of phoenixing. But the report to which you refer, done back in 2012, was done by PwC. It was basically updated in 2015, 2016, and it gave a bit of insight into the size of the size and ramifications of phoenixing over that period. And I actually took some statistics, and I'll give you the updated statistics rather than the 2012 statistics. But in 2015, that particular study was called The Economic Impacts of Potential Illegal Phoenix Activity, put the cost of phoenixing to the economy at between 2.8 billion and 5.1 billion each year. And that was based on activity for the year 2015-16. And it estimated that the overarching costs to the Australian economy were around about 3.5 billion, with a loss to GDP of about 0.21 of the Australian annual GDP. So even though 0.21 of the Australian GDP may not sound a lot of money, this turns into a lot of money when you're dealing with financiers, you're dealing with employees, you're dealing with retirement plans, you're dealing with creditors. You know, these guys are the guys who feel the impact of that. And to that end, they also did some further deeper investigation into that and found that the cost of business in the form of unpaid trade creditors was between 1.16 billion and 3.17 billion. They estimated that the cost of unpaid entitlements to employees was between 31 million and 298 million, and the cost of government in the form of unpaid taxes and compliance costs was around 1.66 billion.
Wow.
I'll give you an idea of the size of what we're talking about here. If it's not curbed properly, I mean, the government reading in relation to this, particularly in relation to the most recent reforms, you know, talk about it being unethical, illegal, and so on. Effectively, illegal phoenixing is asset stripping, and it's against the law. It's stealing.
So you mentioned those reforms before. What were some of those reforms?
Look, I think in a sense, going back over the years, the reforms that people have tried to impose onto business in relation to Phoenix have been very difficult to do. I think the most successful one so far has been the 2020 the new act. It was called the Treasury Laws Amendment Combating Illegal Phoenixing Act of 2020. Came into effect on the 18th of February 2020, and what that did was really take phoenixing, illegal phoenixing, hit it on the nose with specific offences and penalties for those offences. And I think that's been the most important change that we've had in most recent years. But don't forget that liquidators have had, and the regulator have had other areas in terms of what's available under the Corporations Act that they can work on as well. But the most recent legislation was that particular piece of legislation in 2020. What's topical about that now is a recent case that we've had, and that's tested some of the things that came out of the act and given us a little bit of a guidance on how liquidators might be able to act with that legislation in the future, and not only liquidators but creditors and the regulator as well.
Okay, interesting. So, mate, what are some of the, let's call it the phoenixing offences? What are some of the offences that you can take us through?
Look, I think it's a pretty well easily. At our level, it's easily defined, but it turns into so many different things. It's simply the moving of assets from one entity, an insolvent entity, to another entity, where the parties are related, but not necessarily where the parties are related. And the reason that is done is for the purpose of defeating the creditors of the first company. That's basically what phoenixing is. And in the case that they had recently, this was actually borne out in a company that was started quite early, had operated for a while, and then a transaction was entered into to transfer the assets from one company to another company that had basically been incorporated the day before or the week before, and then the same day that it was transferred, there was the appointment of a creditor's voluntary liquidator. Now, that's going to be a red rag to a bull who's the liquidator, but it was also tested in the court, and the courts agreed with the liquidator in that particular case. And having said that, that's the only court case that I'm aware of at the moment, and that was handed down in May of this year, so it's only a couple of months old.
Okay. Which parties? We're talking about the different parties who can be potentially liable under the legislation.
Well, obviously the director, if the director's involved in making the decision to enter into a phoenixing transaction, and also, by the way, under the legislation, there's actually a definition for the actual type of transaction what we're talking about. It's called a creditor defeating transaction. So a director who enters into a creditor defeating transaction is one person who could be liable. The other one is their financial advisors, and so accountants, lawyers, pre-insolvency advisors are potentially in the firing line if they're engaging in that sort of stuff.
Okay. So is there a recent case, I think you spoke about something in May, but is there a recent case or a story that you can share with us of how to work through it?
So the actual name of the company was Re-Intellicoms 2022.
Okay.
As I say, it was handed down in May of 2022. Basically, the director of Intellicoms entered into an agreement with a company called Technology Fluenti to transfer the assets to the second company for an amount of about $20,000. The same day, and by the way, this particular company had only just been recently incorporated. And not only that, the director of that particular company was the sister of the director of the first company, of Intellicoms. So, you can start to see some things starting to be set up here. But anyway, they did a transfer of some assets from the first company to the second company. I think the transaction was about $20,000. The liquidator coming in had a look at it. He became concerned about some issues involved relating to the transaction, obviously the way it had been set up, the background to his appointment. Interestingly, in this particular case, the director did not consider voluntary administration. He went simply to creditors' voluntary liquidation, and so he took a closer look. Eventually, he took it to court, and in the court, it came out in the court hearing. It came out that this particular assets that had been transferred from Intellicoms had varying valuations going up as high as $11 million. So anyway, there was a bit of argument about what the defences were relating to the alleged phoenixing activity, and it was ultimately found by the court that they had been that the directors had engaged in a creditor defeating transaction, and it was deemed to be an avoidable transaction. And so that opened up some interesting things for liquidators and lawyers who assist us. That we can actually look at those sorts of transactions. I think one of the things that's quite interesting is that this was not a high value transaction that we started with. By the way, Hall Chadwick was not the liquidators in relation to this matter, but it was not a high value transaction that the liquidators were looking at. It was only $20,000, and a lot of advisors and accountants and people think that just because it's such a small amount of money, nobody's really going to poke around at it. But once you get into it and you see that there's something underlying that, then a liquidator starts to get quite interested in it. And that's particularly what had happened in this case. Interesting, there are some defences to the creditor defeating transaction, and they are, lack of participation in the company and a few things like that. Interestingly, if the defences are not available if the credit-defeating transaction has occurred within 12 months of the eventual winding up of the company. So, directors need to be pretty careful if they are engaging in that sort of in this sort of transaction, and it is going to be deemed to be a creditor-defeating transaction. That they just need to be aware that a defence may not be available depending on the time frame that they're involved in it.
And what was the penalty involved there?
Look, the reading didn't actually hand down the penalty, but I think what actually my reading didn't hand down the penalty, other than for the court to determine that it was a creditor-defeating transaction, and that it was a voidable transaction, which gave the liquidator the ability to go back over to the other company and resume either the asset back to itself or resume the value of the asset back to itself. And but I think the point that you're making is that it's not only civil orders that can be obtained but from the court, but it's also, and this was borne out, that there were potential for criminal orders as well. But in this particular case, at least the time that I'd read it, there were no criminal orders. Interestingly, there was a discussion about whether or not the liquidator could have gone back to look at other transactions other than the one that he was involved in, so things beforehand. That was not tested. The other thing that was discussed but didn't need to be tested because the liquidation had already been made was that it's ASIC themselves who could also go back to the to actually undo the transaction, a creditor-defeating transaction, would be able to undo that transaction without having to go to court to get the orders. I think there'd be other people who could give me a view on whether ASIC would take that course, but I think ordinarily you'd see it through a winding up application and an appointment of a liquidator. Having said that, a creditor with the consent of a liquidator can also take that course of action to a court as well. Okay.
To everyone's online, if you've got any questions, throw them into the Q&A. We're going to jump to some questions soon if you've got them. So if you've got any questions or anything you'd like to ask Richard, please do so. Throw it into the Q&A. That's probably the easiest. Rich, from a let's call it, I know Hall Chadwick works with a number of different firms, obviously providing the advice, different layers of that professional service advice that you guys have, certainly in that insolvency, pre-insolvency area. What sort of recommendation do you provide to the firms that are online listening to this, to what they should do and what they could do and how they could engage with you guys?
I think the emergence of this legislation has allowed practitioners to learn that if they're going to recommend transactions like this, that they do it using the formal insolvency processes, whether that's through a voluntary administration or a scheme of arrangement, or potentially through a creditor's voluntary liquidation, or anything like that, even under safe harbour, that they provide the security mechanisms to help practitioners avoid coming under the scrutiny of the courts and the regulator relating to the inclusion of financial advisors in these sorts of transactions. So I think that I actually had this with a client yesterday where he's not yet a client, we're actually talking to him. We're talking about a transaction that he had entered into several months ago, and it became clear that this particular transaction looks like it may be undervalued, and ultimately, if we're appointed, we're going to have to take a close look at that. I would be recommending to accountants that they get somebody like us involved at a stage during the process of when they want to make these transfers, and possibly where you can, look to have the transfer made or ratified by the liquidator, even entered into by the liquidator rather than by themselves, particularly if the parties are related. The scrutiny that's available for a liquidator to have a look at it, or an administrator, a scrutiny to look at it and investigate it and make sure proper values are done, that's available to a liquidator. But it's a lot harder for an accountant to be able to do that, keeping in mind that the defence it is a defence to say that the transaction occurred under a deed of company arrangement, or under a scheme of arrangement, or under under safe harbour potentially, or even under a CVL. So that'd be my recommendation. Get your local friendly liquidator involved early.
I was about to say
at the right time. I mean, obviously, liquidators have to be careful that they're not engaging in conflicting work as well. I know in our firm, our liquidators don't want to get involved where they could be considered to conflict themselves out of a potential job where they're giving advice too early in the piece. But a good, honest discussion with a liquidator beforehand goes a long way to being able to sort it out without problems after the event.
Brilliant. Thank you. That's a good little recommendation to all the firms that are online, I think. Questions, if you've got them, chuck them in there. If you haven't, that's okay. We'll probably look to wrap up. What have we gone? 1:26. So we try and wrap these up in 30, 40 minutes, which is always really good. Certainly on
it's not like you, Paul. You keep going and going, mate.
There's a few online that probably say, get him off. No questions coming through, but look, if you want to type them in as I quickly look to share some other information with you, that'll be fantastic. So if you've got anything you want to ask of Rich, reach out. But what's the best way to get a hold of you, Richard? Obviously,
look, just certainly through the whole Chadwick website. You can go on there and look up our team, and you can contact any of our team on there. It's just click and you get straight through. The other thing is through LinkedIn. Always happy to talk with people through LinkedIn. They're the best ways.
Brilliant. And to be fair, I suppose most of you are probably in touch with Danielle anyway, so you would have got your invite to come here through Danny. So I'm sure Danny would touch base with if there's any sort of way that we can help. This is probably fantastic. So
I think it's probably also any of the other partners of Hall Chadwick as well, Paul. I know that we've got 3 of our partners. We've just recently opened an office in New Zealand. So 3 of our partners are over there this week. Otherwise, we probably would have had them here. Actually, Brent Kidgerine is one who's over there. But you guys, I'm just looking through the list of attendees there, and I know that some of you are familiar with the other partners, and they're all pretty good guys.
Yeah, they are. Office in New Zealand. That's good to know. It's been a while since I've been there.
The thing is, you can do webinars over you don't need to go there, mate.
Yeah, true. This has all changed everything, hasn't it? So,
hasn't it? Yeah.
Again, if you've got a question there, throw it in there. Otherwise, Rich, thank you very much for sharing in our Lunch and Learn workshop. This is the sort of thing that we want to continue to bring the firm, more importantly, your team members, to continually learn as well. So let me just quickly check. There's no questions coming through, but I will check for the next minute or so to see if there's anything else coming through. To all of you that have joined us, thanks. A massive thank you. This is obviously for you guys. So we tend to, I know Danny asks questions about topics and what would best suit you. So we'll continue to probably bring you more in the insolvency world rather than the tax world, which you probably get smashed a lot with. So these sorts of things are always great. It's on the first Tuesday of every month. So look out for, hard to believe we're in August. And the great thing about September is we'll be in spring. So get away from this cold weather. So continue to be a part of what we're doing. Just a quick little update. I know I had my Empire Masterclass, my Accountants Masterclass series last week with Daniel Spitty. I got my new one coming up. My next live show is on the 18th of August. I will be interviewing the IPA CEO, Andrew Conway. So he's actually a really, really good lad. So for those of you that haven't met him and don't know too much about him, he'll be here via Zoom. So you'll no doubt get an invitation in your inbox. So hopefully you can join us on the 18th of August. And Andrew Conway will be talking about all sorts of things to do with the Institute, which is always fantastic. Let me check questions. Any parting comments, Rich?
Yeah, look, I think the main thing, Paul, if we could just tie back the previous webinar that we had, where I had the pleasure of speaking with you, back to this one, is, when you've got clients who are talking to you about the problems that they've got, and they're considering, how they can have a continuing business to move forward with. And, I've referred to the things that I've worked at in this restructuring space is to make sure that you have viability and sustainability. If you can confirm that there's a potential for viability and sustainability, but you need to be able to move this to a new entity for whatever reason. You may not be able to get a deed of company arrangement, a waiver, or for some reasons. But if you have those clients who are looking at that, get to them early and just help move them to a position where they're not going to fall foul of the tax office in relation to payment arrangements, director penalty notices, but also not going to fall foul of the Corporations Act relating to director offences in insolvency, but also in relation to this new legislation that, if you stop and just have a look at it and work through what the definition of the creditor defeating transaction is, and then look at the defences that are available and then consider the options from there, I think that that's the proper professional advisory way to be able to work through this.
What a way to wrap up. That's a great piece of advice for everybody that's online. So thank you, Richard Croaker. Thank you to all of you that have joined us, not all of me that have joined you. That just throws a spanner in there we don't want to address. But yeah, look, thanks. Hope you've enjoyed this. Again, this is for you guys, so we hope you've enjoyed everything. Share it with your team. This will be uploaded shortly as well. If you want to get a copy of it, it'll be uploaded to our PPE TV YouTube channel very soon. So we'll share the link with you. And but otherwise, till we see you next time, thanks for joining us and enjoy the rest of your day. Thanks, Rich.
Thanks, Paul.